Unless there are any points for anybody else? Yes, Rex?
Yeah, as you've also already sort of outlined, PINS is looking at things and how the process is going and possibly reviewing their procedures in the light of this and other ones. The one thing that strikes me as rather perverse as it stands at the moment is that the first approach that a DCO has to satisfy is that it's in the national interest. The scheme is in the national interest. I think I've got that right. Now, River Oak or any other application under a DCO has to go to extreme lengths with its environmental plans and surveys, etc., and other things, which, depending on the scheme, which can be very, very expensive. Now, it seems to me that you should be able to satisfy you meet the primary one that you have to meet before you go down all the other routes of having all these expensive environmental surveys, etc., which really are wasted if you don't satisfy the planning inspector on the first one.
Well, I mean, what I would say is that the planning inspector provide a process where an applicant can consult with them over a period of time, and River Oak obviously engaged in that for, well, 2 and a bit years, where they were meeting with them on a regular basis. And I would say that in the first couple of meetings with PINS, if it was clear to PINS that this was never going to be acceptable as a DCO, they would have been told that very early on. So I think that's when the vetting process would occur, before it even gets to the acceptance stage.
Well, perhaps I misunderstood or the press have got it wrong, but my understanding was the press report, and I know I accept what you've said about press reports, I entirely understand all of that, but that was one of the things that it was reported that PINS wanted some further information or wanted to be satisfied that it was in the national interest, and it seemed to me that that ought to have been the first thing before anything else.
Yeah, I think, I'm sure people will correct me if I'm wrong, but my understanding is that there are a separate group that have discussions with applicants leading up to an application. The application is then looked at by a second set of planning inspectors and so on, and then if it's after it's been accepted, it goes on to a third set, including named inspectors. And so, obviously, in those discussions, it would appear that those conversations will have happened, and they were convinced that it satisfied the at least 10,000 air traffic movements. It's this second set that suddenly are questioning or appear to be questioning it. I don't think there's any problem with that. River Oak wouldn't have gone down this road if they weren't convinced, and their experts weren't convinced that this does qualify as an NSIP. So it just seems to me, and many others, that they're being over cautious. That's PINS, I'm saying. I don't know if that addresses your question or not, but
Yeah, well, I think that's the primary thing you have
Yeah,
to satisfy first before any of the other is relevant.
and RSP are satisfied that it does qualify.
But the question is, are PINS satisfied?
They will.
Rex, I think you have to accept two things. One is, as John said, that there have been a number of meetings over 2 years, all of which are minuted. I mean, it's all a matter of public record, all completely open and above board. If the planning inspectorate had felt at any stage that this wasn't going to qualify, they would have said so. Because you don't allow an applicant to go down the roads that they've gone down when there's no prospect of success. But even if up until last week that was still in doubt, I think what the Secretary of State said at the dispatch box on Tuesday, indicating very clearly that we have to use all of the assets that are available to us to get us from A to B, underscores that national importance.
Right.
And I'm not a genius, but I would imagine that that's a point that River Oak will be making to the planning inspectorate when they see them.
Something I would say actually is something I would say is that you will all remember the High Court case my family was involved in And my understanding is that if Anglo wants to sue anybody over this, it will be effectively suing the government. So, so I'm not at all surprised to see them be overly cautious. That legal team is formidable, and if I had to call it, I would say there will be a challenge. So they're going to try and really make sure this is exactly spelled out the way it needs to be spelled out, so that when it goes to court, it can be dismissed very quickly. And if anybody thinks they know better, I'd like to hear it.
Any challenges of that kind can only take place after a DCO is granted. If the application were to be refused for examination, River Oak would have the power, River Oak would have the legal authority to challenge that by judicial review immediately. But any questions which are raised by the landowner or by anybody else who has a relevant and sufficient interest in the airport would have to be done only after the Secretary of State makes a judgment on the entire DCO. And under the rules of the Planning Act system of 2008 as amended, the Secretary of State has an unfettered discretion to give whatever weight he wishes to all the relevant factors. It therefore is extremely difficult to have a successful judicial review of the DCO process. This is not on all fours at all with the kind of position that TG Aviation felt we're in. They were in a position where the power and the resources of the legal team that was arrayed against TG Aviation was formidable. But in this particular case, what they would be taking on is not just the legal services side of Her Majesty's government. They would be taking on the entire gravitas of Whitehall. All the different interdepartmental meetings that we will know nothing at all about. We tend to look upon this as the Planning Inspectorate acting in isolation, or the Department for Transport acting in isolation. But these matters, as we see, are interdepartmental. They go across the whole breadth of Whitehall. And there will be, I'm sure, from my own experiences as an historian and also from the legal perspective, I'm very aware that the way Whitehall works, there would be meetings of officials in interdepartmental meetings. There will be meetings of ministers in interdepartmental bases, and there will be mixed committees that have combinations of the two. And these ad hoc and standing committees of the type that we will not know about, they will not be something that anybody can do an FOI about, because it's all subject to a 30-year rule. All of these things are going on in the background. So if Anne Globe and Mr. Musgrave and Mr. Cartner wish to take on the whole of Whitehall, well, I don't think that we should give them much credit.
Well,
I've spoken about a hope to have a scholar flying from Manston next year. Obviously, if there's a judicial review, and if they were to apply for an injunction on the basis of that judicial review, that would be a problem to get the airport back operational again. So, for my money, any delay that gets this to a position where, if there is any form of legal process that it's a quick one, that the government can effectively bat it into the weeds, that is the right answer. So I personally don't mind this delay. If it prevents a bigger delay later, it will be a big problem if there's an injunction at the end of this.
There won't be an injunction because the system doesn't allow it. You have 6 weeks in which you can apply for leave for judicial review after the order is granted. If you're outside that 6 weeks, you've lost it. That's it. So there won't be any kind of, it'll be a
And I thought-
very, very fast process. You get 40 days, basically. That's it.
But if it takes 9 months to arrange the case, or whatever it takes in the High Court, or wherever it's at,
Well, you don't have a right to judicial review in this country, you only have right to apply for it.
JP and I have been discussing this for 4 years.
And it's going to go on, I think. But
Yeah.
are there any other points for anybody? Yeah, sorry.
If they've been asking for these things now, which could have been asked for at the next stage, does that mean that when we go on to the next stage, that's going to shorten that time frame?
Yes.
Right answer.
Effectively, yes.
Yeah.
You can only apply for the information once. If the information is there, it's there.
Yeah. I mean, those questions will be asked
Yeah.
by a separate team, but the answers
The
are
answers are there, yeah.
I've got one question.
yes.
All this process goes through, DCO's granted. Ask Brian, how long before we can see his planes flying at Maidstone?
Well, once the CPO element has been comes into effect, then River Oak, as I understand it, are then owners of the land for light aircraft. And again, I'm no flying expert at all, but my understanding is that they can land almost straight away.
No, it is straight away.
Yeah.
It is literally down to whether the runway is safe to use.
Yeah.
The owner's permission, the second Chris Grayling signs that piece of paper, then Manston is owned by River Oak. They can give permission, so the aeroplane can be literally approaching the runway, and that signature on the piece of
What
paper,
about-
and they can go,
What
we give you
about the
permission to land,
lines?
bang.
Does that make any difference to the safety
Sorry?
of the parking lines that's been put on it?
I think
No.
I would obviously somebody would need to. I mean, the safety element. Obviously, somebody would need to go over the runway and check the state of it and so on. So there may be a couple of days delay, but I don't. It's going to be pretty quick.
David,
Sorry.
I think they have to be cleared off because it will be a slip hazard.
Right.
So Roger, you can clarify something that I really am not sure about. I do know that not every DCO is done by way of a statutory instrument. This one will be. Now, obviously, when you have a statutory instrument, there is a period of time during which that is laid before Parliament. You have two different types. You've got affirmative and negative resolutions. This one undoubtedly would be a negative resolution. Now, my understanding is that normally there is a 40-day delay between the time that something is laid before the House of Commons Library and for examination, and the time that Parliament may decide to devote time to debate it. There isn't a cat's chance in hell that this would be debated by Parliament, but that 40 days would normally elapse. And then after that, it becomes law. Now, my understanding would be, or my surmise would be, that it wouldn't be on the signing of the thing by the Secretary of State. It would have to actually have that 40-day period during which Parliament has the option of considering it. Am I right?
I genuinely don't know.
You ain't the only one.
I don't know. I think it's probably academic
Okay.
anyway, because
This,
in the great scheme of things, that 40 days is going to.
this doesn't really matter, but I mean,
I think so.
I think you might
I can
actually
find out.
have to wait
Um,
for that to become law.
It's very difficult to pray against a resolution. You can do
Yes.
it, but it's very difficult.
Exactly.
And I can't recall it being done successfully. Doesn't mean it can't be done successfully. I can't recall it. But I can check it.
Thank you.
I don't know. Like most people, I'm not an expert on development consent orders. There are very few people who are.
Does anybody know if a DCO has ever been legally challenged? I guess they must have been.
It's extremely unusual for a DCO to be successfully challenged, but it has, I think, happened, I think on one occasion, maybe more now, but It's very, very rare. But as I say, in this case, it's definitely being done as an SI.
What we are all very aware of is that this it has considerable potential implications for Northwest 3 and for HS2 and those processes. So I think it's in everybody's interest that this
It's done right.
is done right and smoothly.
Now, I'm conscious of the time, and also I'm conscious of the fact I've been staring at those delightful cakes up there, and I have noticed, although again I'm no medical expert, I'm sensing, looking at some of your faces, that your blood sugar levels have dropped to dangerously low levels, and so actually we're going to lock the doors until all the cakes have been bought. Seriously, please, if you can, then buy some cake. And I'm not sure about the burger situation.
I'll cook some more because I know there are a few people that didn't get them.
Yes, so we'll get that underway. The bar is going to be open for a while longer, if people do want to stay and have a drink and a chat. But other than that, thanks very much for all for coming. And oh, it's a raffle. Yes, we have a raffle.
have some tickets.
What are we going to do? We sell the raffle tickets first, and then we'll do the raffle. Yes. Yep. Okay. Right. Raffle tickets over there. Thank you very much indeed. Thank you. Cheers.